What are we laughing about?
The last clip with a guy belly flopping.
Oh,
Really deep into a pool. I don't know why, but for some reason that one always just like makes me giggle at the very end.
see, I was too distracted by the cats and
Oh,
the kittens, but
of course, of course. Yes, yeah, I love it. I love it. I had to add the kittens and the puppies to make it a little bit more interesting because otherwise it's a little bit of a long intro, but it's fun nonetheless. How are you doing?
indeed. I'm okay. Say Saturday, and I'm, not in bed, so that's always a good start to the day.
That is always a good start. So welcome back. For
you.
everyone watching, you may or may not have seen our first interview with Miss Natalie Wisco. We talked pretty much almost exclusively about the Kyle Rittenhouse trial, but we're not here to talk about that today. We're going to talk about all the other fun LawTube stuff. We're going to get your take on all kinds of different fun topics, like the Drake hot sauce bling, the Cardi B lawsuit or trial, right? I should say, all kinds of fun stuff.
Yeah, I haven't been 100% up with everything just because, like, having a day job, but as one would. But I mean, I'm excited to learn more, and I can talk about the things that I can talk about.
Yeah, that sounds great. And we should have Nate coming by. He said that he was gonna join us. So he might be running a little bit late, but other than that, I'm sure he'll pop in eventually. So we've got a few things that we were talking about a little bit backstage. One of them was the law and crime issue, law and crime versus Nick Rekieta. Which you said that you were aware of as well. How much do you know about
I mean, well, I actually was in Milwaukee County Circuit Court yesterday, and right before I left, Mark had was watching in his office the Edgecomb trial, and it was at the part where like the paralegal was getting kicked out. And I was kind of just in general, I was like, oh, I wonder if, anyone's had anything interesting to say on this, because I hadn't really been super, following it just because of other things going on with my work. And then I kind of realized that I had started with opening statements because I wanted to see the opening statements. And that's when the issue with the stream being blocked for the prosecution's mostly opening came on. And I just was like, well, this is, fucked. Like, what's going on here? And kind of followed it from there.
Yeah. So I guess you're aware that he got a cease and desist from Law and Crime Network.
Yeah, because I saw alleging. Yeah, he had a different stream later, I think that same day, that he was just talking about that, where he got the cease and desist letter.
Yeah, which is it's kind of interesting, I guess you could say, that they are alleging that they somehow have a copyright in the footage, which is like there's all kinds of problems with claiming that, and also claiming that somehow he's infringing, because he's got in my opinion, I think he has a very strong fair use argument in his own defense. And I think that just the idea that that's copyrightable is not entirely clear to me.
Well, I would agree. It's a public proceeding, and Law and Crime is getting the luxury of being allowed to be there in person. This is a situation where, honestly, that courtroom is so tiny that they're in right now. It's kind of absurd, actually. There's maybe like 12 seats for the public in that room. And that's for everybody. The entire thing in Milwaukee County Circuit Court, like, there had been an incident in the past. So all of the criminal courts are like bulletproofed glassed. The entire thing, it's like a plastic cage. And there's, for the most part, a very small piece of, for the public. And just reporters being able to be there and stuff is very, significantly limited by the space constraints in those specific courtrooms. Law and Crime is getting a luxury by being there. And I don't think that, just strapping your symbol on something that is, more or less being, in that context, I don't think that's right.
Yeah. And Nick was going through on his live stream last night, he was going through the various court orders about the cameras being in the courtroom
Mhm.
throughout the various trials that have happened recently, like the ones like Kyle Rittenhouse,
Mhm.
Judge Kim Potter, and he was going through the sort of restrictions that were placed on each of those, and Judge Schrader in I mean, he explicitly said, like, no one is getting a copyright
Mhm.
ownership in any of this footage by virtue of streaming it or
Mhm.
whatever, and so. And I think the Kim Potter trial, the Kim Potter order also said something similar. But the one for Edgecomb, which is the one that is at issue in this
Yeah.
particular situation, apparently it was much thinner, much less detailed, and so it seems like Law and Crime Network is trying to sort of use that absence of detail to say, well,
Yeah.
therefore we have a copyright claim in this. But I wonder, I wonder, and I know Nick was asking whether any sort of local rules would say anything about that, about whether, whether it's just sort of like commonly understood and it doesn't need to be explicitly stated in these orders. I don't know if you would know, but
I mean, I don't know. I got the local rules actually on my my bookshelf over there. I can look at them, but no, that's not anything I've ever heard of.
Yeah,
Is I don't know if it's something that necessarily Brovsky would have thought of or maybe thought was necessary. So I'm really not sure about that because I
yeah,
don't know. At least as of late, they haven't had anything that's been like this big and televised in the past, at least to my understanding, knowledge,
yeah,
and since this has kind of become more of a this format of the commenting on the trials has become an issue.
yeah. Yeah. And it seems like that's like the real big issue here for law and crime, or at least the motivation for law and crime is that they're going after him because he vastly outpaced the views that they were getting for
Yeah, that's.
just
I think
the basic.
they're just kind of butthurt. So,
That's what
I
it seems
mean,
like to me
yeah,
too. So but anyway, but I think that the way that the legal analysis is so far shaking out is I it seems like he's going to be okay in my opinion. So
I mean, I think so as well. I think it's when it comes down to it, I mean, it's not like it's original material on law and crimes aspect. They're just
yeah,
being able to document it.
yeah,
So
yeah,
there's no
and it
editing
doesn't.
involved. There's nothing. It's not like there's any
Yeah,
significant amount. There's no real amount of work product involved in it. I mean, granted, they have to set up their stuff. Oh, that's it's not like anybody else wouldn't do that if they had the opportunity. So
yeah, and I think that that's one other point that, or a couple other points that kind of came up through Nick's reading of the orders, was that, not only is this pooled for all media sources, but the order doesn't say that they can't post on social media. It just says that it can't be live streamed by certain news outlets. So it doesn't say
mhm.
anything about Nick's not a news outlet, and he's
No,
also, and he's rebroadcasting it. There was nothing about
yes.
rebroadcasting. And
Well, I mean,
anyway,
I don't
so
think is it technically count as being live. It was delayed. I mean, eventually. I don't know how we get into those minute details, is because
I
this is
don't.
all beyond my scheme of practice. But if they're gonna
Yeah.
start being fighting over small details, you can get into things like that. It is a rebroadcast.
Yeah. Yeah. So yeah, anyway, but that's and there's, and as far as I understand, because of the restrictions on the number of cameras, where they're going to be placed, the way that they're going to be pulled, that also puts a limit on the editorial decisions that they can make, or creative decisions that they can make.
Mhm.
So which would also which would mean that that's
Yeah.
much less likely that they are actual authors under
Mhm.
the for purposes of the Copyright Act.
Yeah.
So anyway, well, let's do a few super chats, because we have some questions for you. Natalie Eckert says, "Hi Natalie, kudos for your work on Kyle Rittenhouse. What kind of law do you practice day to day? Any other homicide cases?"
My firm in general does almost entirely criminal law. I mean, we do have an offshoot every now and then. Like we have a random federal civil case right now, just because it's former clients of ours in federal criminal court who I just don't think necessarily get along with other people. So they wanted to hire us. So we're dealing with that. But otherwise, I mean, we're almost exclusively criminal traffic, restraining orders, quasi-criminal things. Like restraining orders in and of themselves aren't criminal, but they have potential criminal consequences associated with them, as well as things like CHIPS, child in need of protective services. Those also have quasi-criminal consequences and frequent overlap with criminal courts and proceedings. So like if somebody's in a CHIPS case, sometimes there's also, a criminal case associated with it. And so we do those things just kind of because they do cross borders, but for the most part, we just do criminal and traffic.
Okay. That's interesting that you do some of those where they do overlap, because I wasn't sure if you guys would just say like, okay, well, so as soon as it gets into civil, like that's someone else. But I guess it makes sense where you kind of need to know the heart of the matter. It kind of makes it a little bit more efficient, I would think.
Well, and a lot of it is, restraining orders, things like that. A lot of the times where we get retained for those are people who've got family law cases, and these are spouses or family members, things like that. And honestly, a lot of family law attorneys just don't like dealing with restraining orders because they actually have to, examine witnesses and things like that, but they wouldn't have to do as frequently in their regular practice. And so they send them to us. And, just as far as keeping up and being on your toes as an attorney, if you're going to be litigating, you want to be litigating all the time. So, yeah. I mean, at a certain point in your career, like where Mark's at, he doesn't do things like that because he doesn't have to. But for the other part, it's if you want to be a good litigator, you have to litigate as much as possible. And those are the type of proceedings. Yep. And those are the type of proceedings that, you actually get to litigate to the extent that, you don't necessarily get to otherwise.
Yeah. That's fair. Well, cool. That's good to know. Zmako Gelka says, if you have a salary attorney, is there any cost to a butthurt cease and desist letter other than reputation? Probably not. My guess is, I mean, unless they have like bonuses that are attached to the number of billable hours that they do, because most, I mean, if it's an in-house counsel, then you have they may or may not have billable hours just to sort of track their time. But I don't know if there would be any bonuses attached, but at some firms they do. Yeah, I don't know. Oh, and we have joining us is Mr. Nate the lawyer.
Hey, how you guys doing?
Nate, how are you?
I'm doing okay. I did a store run and it got kind of long on me, so I'm like, you know how it is.
Were there any items in the store, or did you just go to observe the bare shelves?
Well, thank God, we've got some things in the store. Only problem is that things are so expensive now. It's just like ridiculous. Like like $1 doesn't go as far as it did a couple of years ago. Well, what I mean, a couple of months ago. What am I talking about? Years ago?
Yeah, that is very true. But anyway, well, this is Natalie Wisco. Now you guys
have met.
Natalie.
Nice to meet you, Nate. I already am a big fan of yours because the first 3 letters of our name are the same. So
there you go. Nat.
I loved your work on the Rittenhouse trial. I was like, fighting it up, boy.
Yeah, I will never get over. And I still to this day, you would think after the Legalbytes thing that I would maybe have stopped doing it, but I can't. My head does not process the M with another letter being anything other than Milla, because it's medical family milligrams, things like that. That's what I think, and I still do it all the time. I'm like Legalbytes. So I mean, I do know what they mean. I just apparently can't say it correctly.
Well, a lot of people don't realize when you're under pressure, especially in the court, of course you make mistakes. People have this I think unrealistic view of lawyers, like we're all the people from what's it called, like Law and Order or Perry Mason or something like that. And it's
we're
just
actually
not
true, right? Scripted. No one's making our scripts. We're saying them as we think of things. So yeah.
Oh man. Well, Shane M wants to know, Natalie, if you've ever seen Borowski smile.
I have actually seen Borowski's smile.
Okay.
Interestingly enough. But no, I was telling Alita about this before we got on, actually. So I went to law school in Milwaukee, and that's where Milwaukee County Circuit Court is. And for everybody who's like aspiring to be an attorney in law school, one of the best things I think I ever did was take classes from adjunct professors, because those are the people who actually work in the community. And I mean, it's really nice to have a professor who's like, you know, top of the ivory tower, but that's not necessarily going to get you so far. And when I was in trial ad, one of the adjunct professors, you know, I had was actually a different Milwaukee County Circuit Court judge called Janet Protasewicz, and she brought in for our finals other actual Milwaukee court judges to, you know, judge our final fake trials. And he was one of the one. He wasn't actually the one where I was an attorney. I was the victim in that case. But I mean, he's another person that kind of is like Schrader in a lot of ways, that he's going to give everybody shit all the time. It's not, it's not like he's specifically going to direct any sort of animus towards a specific party, like our specific side. But no, I mean, I have seen him smile like a couple times. Maybe.
Yeah, but I do agree that adjunct professors, when I was in law school, the adjunct professors tended to be the ones that I enjoyed going to class for much more so, because I really think that it's just because they were in a habit of talking about the law to non-lawyers, and so to explain the law to people who were uninitiated. So when you're going through law school, you're still very much learning a lot. And especially in the first couple of years, maybe not so much in the third year, you know, you usually by that point you've kind of gotten the system down, and you know how to sort of analyze things. But especially in the first couple of years, the ones that were my favorite were the ones who were adjunct for precisely that reason. They just seem to be much better at explaining legal concepts and how everything fit into the grander scheme.
Well, and you got to hustle yourself at some, you know, certain level as well, is when you don't have like a guaranteed job coming up. It's, I want to make connections with people who, you know, you might actually be looking at an associate at your firm by the time that I, you know, get out. Or if I don't end up with the favorite job that I have right away, you know, I can switch over, do things like that. Those are the people in the real world who know how it works, who give you the best guidance, I think.
But a lot of times, like I always felt like when I was an adjunct at a law school for a couple of years, and one thing I found is that the people, the tenured professors, they were doing this for 20, 30, 40 years, right? So, and they hadn't seen into the courtroom for that long. So any of the newer stuff that happened, or any of the, you know, the way the law actually worked in the moment, you know, in the present sense, they really didn't know. They kind of just knew the theory about the law. I remember my contracts professor used to tell us, she's like, she did like one case, but she was like the expert on contract law, right?
Yeah.
But it was kind of like that little disconnect from reality.
Yeah, my contracts professor also did one. She said she did one like case that actually was in a courtroom, and she just completely messed it up. And I'm like, okay, well, good to know.
Yeah, I did take administrative law at one point, and I really regretted it, because I don't, the professor, I don't really know if he understood what his role was in that classroom. So it definitely wasn't to explain things in a way that really made much sense. So, but that's, you know, fun. But well, here's another super chat. Legal question: is cereal a soup, and is peanut butter a sauce? We've got the real hard-hitting questions here today.
Man,
that
is a tough one.
Yeah, I mean, peanut butter, I guess you could say that it's a sauce. I could see that.
I mean, I think it maybe more is like a condiment than a sauce, because like mustard is a condiment, but I don't think of mustard as a sauce. Or like, I just don't know if it's necessarily a sauce. We could go on that forever.
Then
cereal may be a cold sauce. Yeah, I think cereal would be considered a cold soup, right?
Could be, but although even I was thinking about this, even cold soups, typically they're best when they've been kind of sitting for a while, when they've been, you know, they've had a chance to sort of settle. And I don't think that I would agree with that for cereal. I mean, but then again, some people like soggy cereal. Mr. Bites is one person. I don't understand it.
I usually just eat like cereal as like with my hands without milk.
Yeah,
I just like to eat dry cereal. Like,
yeah. Yeah.
I'll have like a glass of milk maybe with it, but no, I'll just
Yeah.
like eat dry cereal.
Okay. All right. Interesting. Thank you, Nerneth.
Ha-vock.
Jonathan
Ha-vock.
Tolbert says Ha-vock.
I love Ha-vock. Ha-vock.
I love it
Ha-vock.
too. I can never pronounce it the same again.
Well, and somebody had said, I think in response to Mark did that the podcast, and I know like Legal Mindset did a review of that, and also Ricada did and stuff with Bronca, but I think somebody had asked, oh, he must have just said Havoc in that because he was doing it to the chat. It's like, no, he actually didn't know until like almost Christmas that was a thing, because I got the pint glass in the mail from you. And he was like, what is this? And I was like, this is you, actually. I was like, it's become a thing.
Did he get his t-shirt, by the way?
He did. He took it. I don't know if he hasn't worn it at the office. I think he's worn it at home though. Because I was gonna make him take a picture of it for me at the office, but he wasn't here when it came in.
Okay.
If he does wear it at the office, I will snap a pic. But
Yes.
he's into his like, I don't know, like gray crew neck sweatshirts when he's not in like a suit. So it's that time of year for him.
Yeah.
He's got like a couple gray and green ones that just make constant rotations.
Makes sense. Makes sense. And do you happen to know if Judge Schrader got his t-shirt?
I don't know actually, because so there's court reporter Karen. I had lunch with her sometime before Christmas, and apparently he's been getting so much stuff in the mail that it's been going straight to the sheriff's office first to make sure that it's safe. So I don't know if
that makes sense.
Yeah, so I don't know what is going on with that because I haven't seen her since then. But there was they were getting so much stuff in the mail over there as well, that everything was going through the sheriff's office first.
Okay, that makes perfect sense. And I would, I would hope that that's actually the case, considering just how much people are either very happy or very unhappy about about the way that the case went. Ricky L. Hendricks says, just curious, do the words Wisco and Wisconsin have a common etymology? We kind of talked about this last time you were here.
I wish they did. I mean, it's really fun just to be in Wisconsin, have my last name be Wisco. But actually, Wisco was Viskol. Visco. It's German. And when my family came to America, it had gotten changed to Wisco. So it wasn't originally Wisco. It was Visco.
Oh, interesting.
Yeah, but as happens when people immigrated to America, names got changed a little bit.
Ellis Island did that quite a bit.
Yes.
A few times, Americanizing these names. Jane Doe wants to know, has Natalie seen Nick Richards' auto-tune clip yet? I don't know if I've seen it.
Saw it this morning, actually, when I was in bed. Somebody, because I woke up and somebody had like linked me to it on Twitter or something, and I did see it, and I did get a good laugh out of it.
Awesome. Andy the Game Maker, this is my brother, by the way. He
Andy.
said J. Crew went out of business last year. That's a low blow, Wisco. I think that's a reference to Arrested Development.
Oh, yeah.
That's a low blow, blah blah. And Britt Cormier, thank you so much for the generous super chat. I really appreciate it. She says, here's the real question. Can I sue a certain fro-haired Canadian lawyer for getting me addicted to the law tube? He and his cohorts keep making videos, and due to my untreated hate condition, I keep having to throw money at them. Thanks, Big Pharma.
Diva's gonna love this. Diva's gonna love this. He's the fro-haired. He's the guy with the fro.
Yeah. You know what? Let's just say yes. You probably can.
I mean, you can sue someone over pretty much anything, but whether that goes anywhere is a different question. So yes, you can.
That's a fair distinction.
Yes, you can, but you might not win.
In Fantasy Die also says, hey, Legalbytes and panel. First, can I get a MAGA country from Nate?
Oh yeah, this is MAGA country, Nigeria. We make fun of Jesse Smollett that the two guys happen to be Nigerian, so we're saying when they said this is MAGA country, they said in a deep Nigerian accent. So it's like our thing.
So that's Nate's new calling card.
Yes, this is MAGA country.
And then they said,
you see, it's just
and then they say, second, what mic do you use? I use the Shure. What is it? What is it called? The M7 something or other. MV7. Sorry, the Shure MV7. I should have this. I should know this by now. And third, Natalie is the GOAT. I agree.
Yeah,
Thanks.
yeah.
And mom
Natalie
thinks
is
so
the goat.
too, but she always thinks
Yep.
so.
Nernieth also says LMAO YouTube chat making it rain for Schrader. Get it.
Boom.
Get it. So anyway, well, let's get into some of these fun recent topics that have been going on. Other than we already talked about Rekida's beef with the
Yeah.
Law and
Yeah,
Crime
which is
Network.
crazy.
Mhm.
And then so what else? You wanted to talk about Britney
Me?
Spears, right? Yeah.
Yeah,
Oh, I
what's
just
up
said
with
that
Britney?
we could talk about Britney. I
Oh,
don't
okay,
know.
okay.
Yeah. You asked me what we wanted to talk about, and I was like, I know that these things are happening right now.
Oh, okay,
You
okay.
start. You start, and
so you
I'll add comments.
Yeah.
You guys got to get me updated with Britney because I haven't been following any of that. After I know her and her sister were arguing a little bit, and some other stuff
Yes.
happened. So
Okay,
what's the latest?
So the conservatorship is officially ended. So she can make all of her own legal decisions. She can enter into contracts. She can basically decide for herself what she wants to do with the rest of her life. The only issue is there were some financial questions about the conservatorship estate there was a hearing on Thursday or Wednesday earlier this week where they were dealing with some of those because Jamie Spears wanted to be paid a lot of money out of the estate for his attorney's fees and for his own fees for his work as a conservator, which he is entitled to reasonable fees under California law because he was acting as an agent of the conservatorship, regardless of whether you think that he was doing a terrible job and he was maybe using it to benefit himself more than the conservatorship, more than Britney Spears. He still is entitled to reasonable fees nonetheless. So they can definitely mark those down because of a lot of the things that he was doing, but still there's probably something that he would be possibly entitled to. So they had that hearing, and there was also at the same time going on Jamie Lynn Spears, probably because she kind of sees the writing on the wall and that the gravy train is getting cut off. She's got her book that's coming out or has come out, I guess, and she's been on this whole book tour where she's sitting down for interviews with Good Morning America and other individuals in different outlets to talk about her book and to talk about Britney Spears. And so this has resulted in, Britney using her voice that she's recently gotten back, taken to social media, talking about how she, she's basically responding to a lot of the comments that Jamie Lynn has been making about her. And she's pretty upset about it for some pretty obvious reasons. This is not a ghost. This is Indy. And so anyway. Oh yeah, go ahead.
But that aspect of it, of them arguing over that seems like a monetary ploy, right? Like, oh, I wrote this book, Britney doesn't like it, so it makes you think, well, let me go read the book to see what Britney doesn't like,
Yeah.
So I think that just might be a marketing ploy.
Well, yeah. I mean, it definitely, controversy sells, right? But I don't think that Britney actually wants it because she's kind of sick of her family sort of using her as a gravy train, right? Which is totally understandable given that she's been the main breadwinner in the family, and it sounds like everyone else has been basically using this conservatorship to sort of live off of her wealth that she's worked so hard to earn. So she her lawyer Matthew Rosengart, who I mean, it seems like that was like one of the best things that could have happened to her in recent years.
Getting her own lawyer,
getting her own lawyer, and specifically getting him because he's a tough litigator and he knows entertainment law, and it seems like that really was something that she was really missing, was somebody to understand the entertainment industry and a lot of the things that are necessary to get things done for someone that's living in that world, because it's a completely different beast from any of us, any of the viewers. It's a whole different world and so many different issues that most of us don't have to face. Obviously a lot of benefits, but a lot of problems that also come up as well. But so he sent a cease and desist letter basically saying there's a lot of things that are being said here that are potentially defamatory, and if you keep talking then there may arise a claim, Britney Britney's asking for you to stop talking about her. You say on social media that the book is not about her. She hasn't, she doesn't plan to read the book at any time soon, but this is what you're saying, is that she's not in the book. So stop talking about her when you're talking about the book.
Yeah, about the book. Yeah.
So it was just, so that was that controversy. And then there was the hearing where, apparently it was kind of an explosive hearing. I cannot wait until the transcript comes out for that hearing, because the two lawyers were really going at it. It sounds like.
Mm-hmm. Well, that's actually how I had first found out about it, was because I saw you said the tweet about wanting to see what the transcript was. And I was like, well, what is this?
Yeah.
And, oh, liar, he's a liar.
Stace on the case. Thanks so much for becoming a member. It's pretty nuts. So the lies that they were sort of alleging was they had to do with what came up in response to the request for fees. So they were, because Jamie Spears and his attorney, they were saying that Jamie acted dutifully in the interest of Britney because he's her father, blah blah blah. Whether you believe that or not is another issue. But and they said that he hasn't engaged in any wrongdoing. So Rosengart, Britney's attorney, filed a response just like a day or two before the hearing, saying, actually, there was a lot of wrongdoing, and here's a list of things, including
the surveillance of her,
surveillance, financial mismanagement, self-dealing, all kinds of issues. And under California law, so California is a two-party recording state. So if you're going to record someone in an otherwise private setting, you need to get that other person's permission. Not every state is like that. I think New York is a one-party.
Yeah, there's some
state,
one-party states. Well,
Wisconsin's a one-party state.
Okay,
I'm not sure about New York. Even though I live in New York, I'm not even sure. But for one thing though, could she even give permission? All right, because wasn't she under conservatorship? So would she be able to even give consent to be recorded? Like who would do that in that case if you're recording her? Wouldn't it be the person? Wouldn't it be her personal conservator? Wouldn't that person give the consent?
I suppose so. That's a good point. Yeah, because technically, it would either be. Yeah, it would probably be. So that's an interesting point too. I hadn't thought about that since now that she's out of the conservatorship. But yeah, during the time, because she was under a conservatorship, she wasn't able to legally make decisions for herself. So that means you can't consent to things legally, typically. So in that case, that would. So I think that's why Jamie's prior counsel, because the lawyer that was there for Jamie at this hearing is new. This is not the people that were there before. I mean, he's apparently hired dozens of lawyers over the course of 13 years, which is crazy. That's always a warning sign on its own, right? Like when you have a client that comes in the door and it's like. Yeah, that they're like, I've had this case and I've had 5 other law firms on this case at various points. Like, whoa.
Well, and it's really hard for the attorneys taking over to actually know what's going on. We were like, when you've got thousands of electronic filing documents, or, if you're not in an e-filing state, having to go through all of those, it's like, it takes so much time to do anything, because if you weren't there to have the predicate information, you have to make sure you're not in violation of a million things that came before you.
Yeah. And especially one that has as much of a history as this one does. I mean, it's and no, I definitely agree. I've been on those kind of cases for a conservatorship specifically, and that was like just getting to a place where we could understand and see what was going on. And that case was like, unfortunately, we had to use a lot of billable hours just to get there. So that can be a potentially large waste of the conservatorship estate just right there, just by hopping over to new counsel.
But if you want to, but I think that also cuts both ways, because if you want to kind of keep things nebulous so you can, dip your hands in and then nobody really knows what's going on. The more you change, then the next person still has to now wake up and go through that whole process. And by the time they get caught up, you're changing again. And then so you're always in this perpetual state of the attorneys trying to catch up to find out what's actually going on.
Yeah. Yeah. So if you're actually trying to obfuscate, then it's a fairly good ploy. But yeah, so this idea of surveillance, I mean, at the very least, I mean, even if it's not, even if technically it was legally allowed because of the fact that the person that would be consenting would be the person that was actually recording, it still strikes in such a terrible way, because apparently, or allegedly, according to the filings, the surveillance was they found recording instruments in her bedroom, I think, and then also there were recordings of her therapy sessions,
and conversations with her attorney. Yeah.
Yes.
Wow.
And that's a huge problem, regardless of whether or not you have consent to do that. That is
because that's the whole point in hiring separate counsel for her.
Yeah.
Even though the conservator is supposed to be, her agent, supposed to be representing her. The whole point in appointing counsel for the conservatee in any conservatorship case is just to make sure that everything's above board, that you don't have somebody that's taking advantage of the conservatee, and that, you have somebody that can draw some pretty clear lines. So, I mean, if you then say like, oh, well, I can make decisions for her anyway, so therefore I'm gonna just, find my way into these conversations and have no consequences for that. It defeats the whole purpose of having that separate counsel.
Yeah, it's weird because it's, on one end, from what I understood, she had a personal conservator and then a financial conservator. If I'm not using the terms of art, forgive me. But if the father was the financial conservator, I'm assuming he would still have to get permission from that personal conservator if he's going to do all this. So it seems like there may be some connection there where, where even though it doesn't look good, but if he can get over that consent piece of it, because I always tell clients, it looking good is not our problem. It being legal is our problem. I don't care how it looks. As long as we get out of here with paying no money and not going to jail, that's where we want to go to. So I'm thinking that may be the way he's at, where, hey, we did all this stuff, but I was totally legit because, I got authorization from her personal conservator.
Yeah. Although, I mean, this case is different from many of those cases that you've had, though, right? Because I'm assuming at least that they weren't also being tried in the court of public opinion, right?
Oh yeah. Definitely.
So that's the issue with these cases that are so public, like, the Alec Baldwin thing. That's really what he's been grappling with in his whole situation, is like he's trying to be his own lawyer in the court of public opinion, and he's doing a terrible job of it by making all kinds of statements to the press, and really digging all kinds of holes for himself, probably legally and definitely in terms of publicity as well. But Britt Cormier says, hire dozens of lawyers to make sure they all have conflicts of interest, just in case someone else tries to bring a suit. Also, when not spending your own money, who cares how much you spend? LOL. Well, that's another possibility. It's another strategy that some people take.
Well, I can talk to that one, Britt. There was a famous case out of West Virginia where the coal company actually did that. They went and got consults from all the local attorneys. There was a mining accident in this. So what they did is they didn't want any local attorneys to be able to sue the company. So the coal company went to all the local attorneys and more or less conflicted them out. So they couldn't represent anyone who was injured within the coal. So then it went to court. And the court said, well, since they did that for that intention, so none of the local attorneys, that they essentially waived that conflict, and any of those attorneys could represent people in that manner. So that's actually an ethical issue. So you can't do that. If you're going to go get consults from attorneys just to kind of conflict them out, that's an ethical issue, and they may still be able to represent that client. So
and then you really put yourself at a serious disadvantage by doing that. Brian Miller says, this is MAGA country. Charlie Eckert says, in Edgecomb, when would the paralegal testify?
Well, the issues with that have to do with authentication, I believe, in foundation for evidence is because, I mean, granted, I'm not super familiar with the first instance that brought up with the paralegal, but I know for this second one involved Facebook posts. Well, with that, you can't just walk in, and this is something that actually drives me insane when attorneys try and do this, is you can't just like walk into court with a packet full of Facebook posts or text messages and just be like, this is evidence. This is evidence. It happens all the time. And people don't understand.
Sounds a lot like what the prosecution was trying to do in Rittenhouse.
Yeah, I mean, it's, like, you have to be able to be like, okay, so who got this stuff? How did they get this? Where did they get this? Because, just because it's a document and it's a Facebook shot doesn't mean that it wasn't edited after the fact. You can't, like, one of the things that slows trials down so much, and we didn't go into it with Rittenhouse because the trial would have been like 3 months long, was the issue of authentication, which is how the prosecutors were able to like deal with that issue with the drone and slip it in with like us not noticing, is because they were like, oh, they authenticated to it. It's like, we authenticated to what we had because we thought that was the whole thing. It's the making sure that what you have is an accurate representation of what you're actually looking at. And as part of the legal team, she can't be in the courtroom helping out with the trial and then also, potentially be a witness later on.
Yeah. Because then you have witness issues that come in conflict with attorney-client privilege, with work product issues. There's all kinds of weird ways that overlaps in terms of what kinds of information you have to give and what kinds of information you cannot give to the other side. So that's I completely agree. That's pretty wild. Hen House Bath Company says Jamie Spears was both personal and financial conservator. He was for a long time, but then who became there was a professional conservator who became at least a temporary conservator of the person. So technically she's been acting in a temporary role, but it was at least a year, maybe 2 years or something that she was acting in that role. So depending on when those recordings were happening, they may have needed to get consent from her, even though she technically was temporary. She still was acting in that role. So basically what happened was, with those recordings, Jamie's lawyer accused Britney's lawyer of planting those stories with the media and trying to go to the media first before making any kind of crazy filings about those recordings. And I think also, and then Rosengart responded saying like, no, you're a liar. Like,
yeah, so you're a liar.
Yeah. So I
reminds me of Princess Bride when they're in the hut with and
she runs out. Liar!
I love that movie, The Princess Bride.
I'm not a witch, I'm your wife.
Bye. Good luck storming the castle. Oh, I love it. I love that movie. Marriage. So anyway, but and another thing that Jamie's lawyer requested was that they completely unseal all of Britney's medical records, claiming that the public is somehow entitled to that, which is I don't understand how someone can claim that. Like that somehow the public has a right to any individual's private medical information for what reason? It's not related to any particular claim at issue anywhere, let alone in this case.
Well, I mean, they're trying to make themselves look better because I think that there's something in there that's going to distract from the issue. But I mean, it's not your right to publish somebody else's medical records. It's just ridiculous.
Yeah. So,
that's crazy. But
the judge did not allow that, and then also the judge decided to refuse to reserve Britney's conservatorship funds, and basically said, Britney, here you go, you can have your stuff. So that was a very big win, because it means that she's actually able to control her finances. She doesn't have to ask for anything from from Jamie. She doesn't have to talk to him about her money anymore. I mean, if he feels like he's somehow entitled to some kind of fees for some work, I mean, at this point, he's no longer the conservator. So after November 12th or whatever it was, technically there shouldn't have been much, if any, hours that he should have been dedicating towards any sort of conservatorship role. So because typically, like, I mean, I don't know how you guys have seen this in your experience, but what I've seen in terms of billing, usually, like, you can't bill hours where you're calculating billing hours or analyzing billing hours, right?
Well, no, you can't do that. But isn't there a wind down? But there could be like a wind down cost. In other words, giving you the documents, explaining to you the situation, that type of thing. Those costs could occur after, you know, the conservatorship is over. But but me figuring out how much you're going to pay me is not part of that process.
Right. And so yeah, understandably, that if it takes, you know, a certain amount of time and money to get the files, the information out of your records and out of your hands and into their hands, that is technically a last responsibility of the conservator when the conservatorship has been dissolved. So I can understand that definitely being part of the fees that would be calculated at the end of everything. But beyond that, then fighting about billing hours, that's where like, as a law firm and doing these kinds of cases, like, I've seen the kind of resignation of, like, oh God, we have to fight about fees. We have to fight about these bills. We're not going to really get paid for this. This is going to suck. But at least we're going to try to get paid some of what we're owed.
Yeah, I think most firms know they're going to get, you know, cut out of some of those, you know, some of their time and some of those bills. Because as soon as you start getting a client start nitpicking you, did it really take you 0.5? Like, why? Like, you know, it's like, you know, so you can't squeeze water out of the stone. So sometimes you just got to just call it what it is.
Yeah. Slash and burn theory says, do you think Elizabeth Holmes will attempt to appeal her verdict? I don't know. Have you guys were you guys paying attention to this case? I know that, like, half of the charges she was convicted, and then half of them, it seems like she wasn't.
I would say all criminal defendants who are convicted should try to appeal, right? That's like the general parlance of it.
You're Wisco, or Natalie,
you're muted.
Oh, you're still muted.
You're still muted.
Let me see if maybe oh, there you go. I think you should. Oh, what? For some reason, your mic isn't working. I don't know why.
Now?
Oh, there you go.
We got you now.
Okay.
Okay,
there's a button I
to literally all of us.
Yes. I don't even remember what I was going to say before. So, I think Elizabeth Holmes' attempt to appeal her verdict, yes, because you have to in that situation. Yes, as Nate was saying, everyone should appeal their.
That makes sense. Okay.
You know what? I'm always shocked when a criminal defendant takes their like the judge gives you like 100 years and they sit there and take it so calmly. Like, if it was me and a judge says 100 years, I'm taking it like I'm like, oh my God, I'm falling out the seat. I'm just crying, you know, I'm all emotional. I'm like, I'm going away for 100 years, then I can act the fool, right? Give me more time, give me another 50 years, you know, F you, judge, F you.
Absolutely. If you're already for 100 years.
I wonder
give me another 50 years on top of it.
I wonder if part of that, though, is like, if it's been so conditioned into you that to stay, you know, to keep your mask on, so to speak, in front of the court, in front of the cameras. Like, I wonder if it's like, if you are convicted in that kind of a situation, that like either that just sort of like your brain just shuts off and that kicks in, or you go into like fight or flight mode where you're just like frozen and, you know, and like barely processing things.
I'm acting a fool. It don't matter at that point in time, right? Like the guys for the Arbery case, they got life without the possibility of parole in the next 20 years. What the hell's another 10 for punching somebody in the face, right? It doesn't matter at that point in time, right? I can get whatever time I want. You know, I'm done. Death penalty, okay. You know, it's over. So yeah, I don't know. I'm acting a fool. But
what do you think, Natalie?
But I won't be in that position.
What do you think, Natalie?
I mean, in theory, yes, of course, I think that everyone should appeal everything, because there's so much, you know, stuff that goes on, and, you know, judicial and prosecutorial accountability I think is important. There's a, as much as it's important for defense attorney accountability. But I mean, I do also understand competing interests, things like that, like money, that is unfortunate. Like, if money wasn't an issue, I think everybody should appeal everything, of course. But, when you're not able to contribute and your family can, there's just so many other things. And when you deal with defendants, it's really hard, because I mean, there's so many problems that happen. It's like, why do these institutionalized problems keep occurring? And a lot of it's because people don't appeal them, and people aren't held accountable. And the reason why that doesn't happen frequently is because people just can't afford to do it, is because you have to have somebody who's willing to go completely, balls deep commitment with all of this. This is just something that like we're doing regardless for the principle of the matter. But most of the people in the criminal justice system don't have tons of money. And that's where all the, errors, for every one person that is able to crowdfund $2 million, how many other people are there who can't? Yeah. And, you get to the point where all of the mistakes are happening in big cases because they happened in the small ones beforehand. And if everyone were able to appeal everything, that would be an ideal world. But unfortunately, we just don't live there. If it was possible, though, I'd say, yes, do it. But, and that's one of the...
For her, it probably will be possible.
Yeah. Well, I mean, and that's something that's frequently more so like... I think federally stuff like that gets better appealed a lot of the times just because of the income thresholds for qualifying for federal defenders is much higher. Wherein, in a state like Wisconsin, at least, the income threshold levels is applying for public defenders. People who are poor still might not qualify for a public defender. You have to be the poorest of the poor generally, and then there's the people in the middle, have to cut corners and stuff like that. So, there are lots of competing interests, but in this situation, yes, I think that she should appeal because she seems to have the resources to be able to do that.
Yeah, that makes sense. And that's an interesting point. I think we may have talked about this last time you were on this channel, that about the weird way in which the justice system really kind of helps people at the very, very bottom and the very top. But the people in the middle tend to be kind of screwed out of legal services because of they're just kind of priced out of the market, or they're just placed at a huge disadvantage because they're having to spend tens of thousands of dollars, usually at least, in order to have some sort of a legal issue resolved, and just sort of squeezes these people in the middle in all kinds of terrible ways. But that's also why I love talking about legal tech.
Well, I mean, and it's not like it's a privilege to be able to have to afford your own attorney. Like, it's not these people are having to, take money out of their retirement accounts, things like that. I wouldn't necessarily call that person privileged, but, there's just so many competing interests, and things like that just really hinder the accountability that is built into the system from actually occurring.
Yeah. Charlie Eckert also wants to know, can the paralegal be called by the prosecution in the Edgecomb case? And if so, how? I mean, if somebody's on a witness list, either side can call them if they have information that they would like to get out of that person. So they would just, they would just like any other witness, there would be a subpoena issued for them, and that would be that. So, yeah.
I mean, because you can have somebody called by the prosecution or by a witness by either side who doesn't actually have to testify, because you go up there and you say, I can't testify because of, attorney-client confidentiality. Well, then that means that the other side can't use that evidence then also.
Right.
Without, having to put the person on the stand. There's, regardless of whether or not they get called by, if they get called by the prosecution, they don't necessarily have to say anything, but then they also can't, be able to do the foundation necessary for the defense to introduce it.
Yeah. Also, Nathan DeBruin. Hey, Nate. Hey, Photo Chad.
Hi, Nate.
He said, "Fact, I had to pull out my 401k before I got my donations because he had to hire
Yeah.
his own representation." And he's like, he's a witness.
Yeah.
He's a witness here. He's not even, he's not being prosecuted by anybody. He's not being sued by anybody. And yet, as a witness, he had to hire legal representation
That
just to make sure that
sucks.
he wasn't being screwed over by the DA's office, right? I mean, that's pretty nuts. That just somebody who is, he happened to be at the wrong place at the wrong time, or the right place at the right time, depending on how you view it, and he had a camera with him, and he took some great photos of things that were going on that were very important and very salient to the case. And so a subpoena was served on him. And so he had to go to court, and because he had to go to court and he had to tell the truth.
Well, if he didn't, then he would either be fined or put in jail. So
exactly. So he'd need a lawyer.
Yeah. One thing I do find today, in the world we live in, is that number one, I think the DA's office are getting way too political, and I think when we come to the politics of it, the ethical code dictates that district attorneys or state's attorneys are supposed to seek justice, not convictions. Convictions are a result, but justice is the means, right? You're supposed to go and search the means. And nowadays, it doesn't seem like they're doing that. And this let's get a conviction by hook or by crook to satisfy the mob is not the way the system. They were supposed to be a check on the system, and I think nowadays there's no real accountability for when the DA goes off the rails and does crazy stuff, because it's just like, well, I'm happy to be free and I go on with my life, but then what about the next person they're about to go screw over? So I think a lot of these ethical bodies in each one of these states need to start really looking into these cases and determining, is this DA being honest and with these facts, and are they really prosecuting just to try to get a conviction, or are they trying to seek justice in the case? Because I remember when I was a DA, one of the first things they told us, they said, the district attorney is in a weird spot because you actually represent the defendant in a tertiary way, in the sense of the defendant is a part of the community. So if that person is innocent and you have evidence of that, you're not supposed, you're supposed to come forward and say, hey, I've got the wrong person, do the right thing based on that. If this is not, you're not a defense attorney and I want just to win for my team. You're trying to win for overall justice. Now, I know that that's aspirational in a sense, but that's really the reason why it's in the ethical code that way. So hopefully, there will be some more accountability on the state prosecutor side, because I think it needs to be.
Well, and I think something that goes into that also, when you think about like malpractice insurance, things like that, how much malpractice insurance were you required to have as prosecutor?
Absolutely none. The prosecutor's office did, yeah.
No, you don't have to have any. And malpractice insurance in general is such a strange thing. And I might have mentioned this last time or not, that like, if you look at the malpractice insurance rates for a defense attorney, it is so much less than like a civil attorney, because you're only dealing with someone's lives, not their money. And, maybe implementing an additional safeguard, something like, that if nothing else, a fine that somebody, just paying for malpractice insurance lets people know that, there are collateral consequences associated with what you're doing, is, whether or not you're going to need it or not. It's, I think a constant reminder to all of us, at least to me, it's like, oh, there is this additional governing body and I can be held, accountable for malpractice, because there's no such thing as prosecutorial malpractice.
Yeah.
So,
well, that reminds me of you mentioned that there's been some developments on Kyle's Law. Did you hear something about that, or Natalie?
I saw it was in the news, and I think that is something with Kyle. I think it was North Carolina or Tennessee or something like that over there. There, somebody introduced a bill regarding Kyle's Law, and in theory, I don't think it's a bad thing, because like I said, I think accountability is great, but I don't know necessarily in that context if it's going to end up having the effect that, people think it might, because of just the way the legal system works. And when you look at like specific cases, as a former prosecutor, Nate, I'm sure you can say it, sometimes, you deal with the facts before you, and sometimes the only facts that are before you are because there's very bad investigation practice, things like that. And some of those things don't necessarily come to light until, later on. I don't know if just, finding a prosecutor who loses a self-defense, trial case is really going to necessarily enact the level of accountability that needs to be across the board, and not specifically just with prosecutors, is, and also you can't get blood from a stone. You know,
Because
like,
we're already making nothing
yeah.
almost as a prosecutor.
You're already
anyway.
making nothing. Is like what point is there winning a $3 million settlement against somebody who can't pay it? But if
It's
you have
nothing.
it against the office or something
Right.
like that, that's a different thing altogether.
Which that's the law in I think it's Washington. It's either Washington or Oregon. I think it's Washington, where this a version of this actually exists, and it's precisely that. It's the DA's office that would be paying the attorney's fees for the defendant in that kind of a case, but it wouldn't be the DA or the, you know, the ADA that would be paying personally. So I mean, I think you're right. I think that does sound a little bit more realistic, to just expand that law into other jurisdictions as it already exists. I wonder, I would like to see some kind of data on how much that's actually been successfully used in the state of Washington or Oregon. I think it's Washington.
Wouldn't there be like
curious.
wouldn't there be like an indemnification / qualified immunity issue, because you are acting under state's authority, you know, so forth and so forth. So generals people understand, if you're an officer of any state, you could be a police officer, prosecutor, whatever, and you're acting in good faith under that authority, and something happens, then generally the state has to foot the bill, right?
Yeah.
But if you then act outside that authority or do something bad, then they don't have to indemnify you. So, but generally they have to indemnify you against accidents and stuff like that. So the state's usually the one that's paying for your mistakes.
Yeah, that's an interesting point too, is that qualified immunity could come in those kinds of situations also. Interesting. I hadn't thought about that.
Well, and personally, you know, from defense attorney standpoint, I'm like, why just stop at self-defense claims? Why can't we, you know, hold them accountable for everything when they prosecute BS cases? Because I mean, that happens all the time.
But you know what? But
so I think that's what I was gonna say is I don't know if it necessarily achieves the end. It's just specifically, you know, making it a niche issue to self-defense. You know, I would like to see that as more of a broad spread accountability. So
the only problem, because I know Andrew is the one that's promoting it. The big issue I find with it in the self-defense context is that the amount of proof necessary to go to trial is so different than the amount of proof necessary to get a conviction. Get a conviction is beyond a reasonable doubt. Just to go to trial, I just need probable cause. So if I have enough, like you know, unfortunately in Rittenhouse's case, there was enough to go to trial. There was clearly enough for probable cause. So even in that case, Kyle's law wouldn't have worked for Kyle, because the prosecutor would have been like, "What do you mean we don't got probable cause? The standard is probable cause. I didn't have enough to get a conviction." Now in that movement from probable cause to beyond a reasonable doubt, that I think is contextualized, right? How good an attorney argues, so forth and so forth. So I don't see how Kyle's law really affects that, unless you're changing the standard from probable cause to something else.
Well, I think the way that the law would work is the way that it does in Washington, which is where they say this is basically just another jury instruction that's added for the jury to analyze it. They say for self-defense claims, if you find that the defendant properly used self-defense and that they're therefore not guilty, then you have another question to answer, which is, you know, how much of the burden did the prosecution prove with their evidence? Did they even get to, you know, 50%, or did they get to a certain level between 0 and just under what they would need to prove to make their case, right? Because they have the burden of proof in any kind of a case for murder. So, you know, if they really have so little evidence that they don't even meet another sub threshold under that, then you can find that the prosecutor really didn't have enough, and that therefore they should pay the attorney's fees for the defense. And it's a little bit of a different analysis than probable cause.
But and that's why I think it fails. That's why I think it fails, because both constitutionally and and I think most states, but even constitutionally, the standard just to even get to trial and have the whole trial is probable cause. Now I may not get past probable cause, right? I might just have enough just to have but I can go through a whole trial and get acquittal on probable, and the jury can say, hey, we thought the guy was innocent all the way through. But that is not a basis to say that my prosecution was illegitimate, because the standard for me to go through that whole trial is not even 50-50. Probable cause is under 50-50, right? It's less than the standard for a civil trial. So, so now to say that, now to have this jury question to determine whether I went above probable cause is not even a standard that I needed to have this trial. So that's what I'm saying. I think I understand what Andrew's trying to do, but I just don't think it's really fleshed out in the real world understanding what the standard needs to have to actually have a trial and what it means to prove the defendant's guilt at the end of trial. But again, that's a an issue.
Well, I mean, in Wisconsin, I was going to say probable cause. Credibility is not an issue at a probable cause hearing. Hearsay is allowable at a probable cause hearing. For example, I don't know necessarily everywhere else. So for us, how I explain to my clients is I was like, if there is information that they can put on that if it was true, you probably committed a felony or felonies. That's the standard. It doesn't matter whether or not that information is true or not. If someone is willing to lie, or if someone, misinterprets something that they've seen to an extent that it could possibly be true, and if it possibly is true, you probably did something. It's very
low standard. Yeah. And for anybody watching or listening that isn't familiar with Kyle's law, we're referring to Andrew Bronco, who's been he put out an idea through his website lawofselfdefense.com to try to change the laws with regards to self-defense in the ways that we've been talking about. So that's kind of been his idea coming out of the Kyle Rittenhouse trial, was to sort of push the idea out there and see if any legislators would pick it up and change their state laws moving forward. So, but I think that there were some states that were looking at it. I don't know if anybody has any plans to actually change.
I do want to. I am sympathetic to it because I don't want to get into the Rittenhouse, but I think what the prosecutor did there was disgusting, right? Like, just straight up, I just lie. It was disgusting. That was horrible. And you want to stop that? Yes, so I'm very sympathetic to that. I'm just, mine is more to fine details, because it's always the devil's in the details. So I agree we should do something, but how we get there, is the problem. So
yeah.
Well, I mean, and I don't have any better ideas. So I mean, it's hard to be super critical when I don't have an idea that could fix it. I wish that there was. And that's the problem with legal in general, is so many people try and make it black and white, and it is not a black and white field. Our justice system allows for situational justice. Prosecutors have charging discretion. Judges have sentencing discretion. This is not a, you steal a loaf of bread, you lose your hand type of environment we live in. And the fact that we allow for black and white, that we don't, that we allow for gray, just makes everything so much more complicated when you're looking to do anything that is inherently widespread, like that type of law with Kyle's law is. I agree that there should be more accountability, absolutely, but I can't think of a good way to do it and still, allow for things to happen in, an expeditious manner, because people don't necessarily want justice 6 years later. And the amount of oversight, things like that, necessary to make sure that these things are done appropriately. I mean, it's not going to go fast.
Yeah. So. Potentially Criminal says this is a way for a jury as the community's voice to say this shouldn't have gone to trial. This wasn't a good use of resources. I think it helps the community shape the policy of prosecution. Well, those are interesting constitutional questions, though. I mean, if it would be potentially unconstitutional, then it doesn't matter what the community thinks or what the community would want to do, would want to say. Like
there's a what's it called? There's a separation of powers issue where charging decisions are by the executive, so the jury's really not supposed to even be dealing with that. Then even with that, there's an issue of the political piece of it, because prosecutors are political in nature. So if the jury and the public and the community doesn't like what the prosecutor's doing, their voice is voting them out, is at the political process. So there are safeguards in place. I think giving it to a jury and to have them judge, the only thing I think they can judge in that moment is whether actually, so it would be a question of law, so it's not even for the jury, is whether there was probable cause. And if there was probable cause, I just really don't see how you can hold the prosecutor accountable for going through a case where they did have probable cause to do it. Maybe, it just doesn't add up.
Yeah. Yeah. And I can see what you're saying. And some people in the chat are saying that Andrew Branca should be here for this discussion. I do agree. Maybe that would be a good thing to have a discussion with him. He's talked about it on my channel before. Also, I had him and Darth Crypto on to talk about Kyle's law, and Darth Crypto had Kyle's pledge that he wanted to kind of put out there. And that was an interesting discussion that we had. But I mean, we could with your guys' perspectives, that would be interesting to have him on too, just sort of flesh out some of these ideas. But Larry and Crystal said, I was arrested in London, England in the late 80s. I couldn't afford a lawyer. All I had to pay was $600 to the court. Then I could find any barrister I wanted. By accident, got very good, and money not guilty verdict. So, well, that's good. That's very fortunate.
Another criminal got away with murder, huh? London style.
London style. And then TZ 1052 New York says, or NY, I'm assuming it's New York. What possible strategy is saying nothing for Chandler Halderson? There's zero chance he was getting off. I mean, that probably, I think in typical, I mean, I guess, correct me if I'm wrong, Natalie, but typically most lawyers don't want their clients to take the stand if they can help it, right? I mean, we talked about this last time you were here.
Yeah, I mean, I think it really and honestly, it's a lot to put your client through as well.
Yeah.
And their testimonies, things like that, always depend on so much. Like Mark and I had a trial a couple of years ago that was, effectively this guy was messaging on, a secure platform with what turned out to be a cop who was posing as, like somebody who's borderline age, looked, under 18, rather looked over 18, but was under 18. And, in that situation, all the client really had to do was admit that he was going there to have sex with her. And that there was like, when you start, but it's hard to explain without getting into like a 2-hour story, but his mother and his grandmother were there, and he couldn't get himself to like admit, on the stand in front of his mom and his grandma, yeah, I was going there to have sex with this girl. I didn't know that she was, underage until afterwards, type of thing. And, like that was such a hard thing to deal with because, believe that it was a mistaken type of thing. I mean, but there are also situations where you kind of have to. I mean, like with the self-defense thing in Wisconsin, it's an idiosyncrasy based on here. Is part of it has to do with the jury instruction. Is you have to have some sort of statement from a defendant about their state of mind in order to get that jury instruction that says the defendant's state of mind at the time was reasonable. So, I mean, if they gave a statement to the police, a long statement, something like that, where the whole time, they were consistently like, I was in fear for my life type of situation, these were all my observations, then you could arguably not have your client testify. But otherwise, if you don't get that jury instruction, you're completely screwed.
Yeah.
And,
yeah, I mean, that was the case for Kyle, right?
Yeah. And that's also, I think where they're going with Edgecomb is because in Edgecomb, they said in opening statements that Edgecomb is going to testify. And, at least from what I've watched, they're talking about, knives, things like that is, and all this darkness. I think they're probably going to try and get into, he was in legitimate fear for his safety at the time. And, when you don't give a statement to police, which you shouldn't do, the only ability to get across to a jury what your state of mind is for you to actually speak.
Yeah. And the same person says, I'm an MD. They had at least a head injury defense with Chaz Z. Worse could have been that the jury did not buy it. I mean, there's also other possibilities, right? Because you could say something else that opens up a whole other can of worms that then opens the door for other witnesses to be called as well to make things worse or add more charges on top of things. So like there's always ways that going on the stand can be particularly risky that are not necessarily even obvious to the general observer.
Well, and when you think about suppression motions, things like that, a statement is suppressed. suppressed because an individual wasn't Mirandized. Well, it's only suppressed as long as the person doesn't testify, because you can bring that up as impeachment. And there's so many, this is only excluded if type of situation. And, is it more important to keep that evidence out or to have your client testify? And a lot of times it's more important to keep that evidence out.
Yeah. Yeah. So, hey, also uncivil law, I know you want in, I just sent you a link, so come on in. York says, oh, do you need to get going?
Yeah, well, go ahead. Read this last one. I'll go after.
Okay. All right. York says, if we need higher standards for prosecutors, would it be reasonable to require for prosecutors to conduct the case under oath and a mandatory perjury charge for lying under a trial? And
we got all that already.
Yeah.
Like I think people don't understand, but I understand the outrage, right? What happened in Rittenhouse is not what generally happens. Like, for instance, if I would have did that here, my behind would have been in some real trouble, right? Because my bosses didn't play that, but every place is different.
Yeah.
I do understand the need to try to legislate that out, but sometimes, they may be different. I just, I don't want people thinking I'm objecting to the problem. I'm objecting to the solution. I think the solution just doesn't work, but I do think there's a problem. And just like Natalie said, I don't know what the solution is, so I'm just arguing from what solution has been presented to me, that and the issues that I think come up. So yeah, I do think I think if it's like with gun laws, if we enforce the laws we have now, we enforce the standards we have now, I think we'd be in a better place. But I think those standards that we have now are just not being enforced. And this is one of them, right? Honesty in front of what they call it. It's I forgot what rule it is. Candor to the tribunal.
Yeah.
Well, if you go out there, you say something that's straight up false, then you should be finding yourself under ethical charges for not being candid to the tribunal.
Yeah. Yeah. So, hey, uncivil law, how's it going?
Hey, it's nice to meet you, Miss Wisco. How are you all
Hi,
doing?
it's nice to meet you as well.
Uncivil law.
As you
again.
As you may or may not know, I was deeply critical of Richards, but I was very praiseworthy of you. I thought you were criminally underused, and when you spoke, you actually had intelligent things to say. I was like,
except for I'm never going to live down the Millibytes thing, but that's okay. I've embraced it.
The order of which the defense attorney spoke was exactly reversed of what it should have been based on what I was observing. So yeah, but I'm very happy, obviously, that Kyle won, perhaps despite some of the efforts of Richards, because the evidence was so unbelievably clear. And I'm happy that you were able to get the result that you needed for your client, and it all worked out in the end.
I don't know. I mean, when Natalie was here last time and we were talking about legal strategy and a lot of the decisions that they made, it made a lot more sense to me than before the behind the scenes look.
Look, it's totally possible I have my head up my ass. This is definitely a distinct possibility, and I don't know the first jack shit of thing what I'm talking about. And Natalie Richards can come along and just slap me upside the face, be like, "You don't know the first thing what you're even talking about, you fool." So that's fine.
Hey, I always appreciate criticism in general, because if nothing else, it makes you address your faults and makes you more confident in the things you're confident about. So,
yeah,
there you go. This is the proposed Kyle's law. Let me see if I can actually copy it from here. It's a PDF.
Yeah,
for Tennessee's version.
Yeah, I'll put it in the thing.
Okay.
I copied it. I was looking it up. It's funny because it has here, in order to support for malicious prosecution, they have the prosecution was without probable cause. So that's which
is kind of difficult, because you how did you get there, and how are you at the end of a trial without a motion to dismiss?
Yeah, with probable cause.
So you got to work on that one a little bit.
You got to. The judge is the one that's got to have the issue with that one.
Okay, so we do have a probable cause kind of situation. Did you want to share it?
It's in the private chat. Just click on.
In the private chat. No, okay.
Nate has said it before, and I've said it before. One of the things that was really bewildering to us about the whole Rittenhouse experience was the state's charging document, their own information.
Doesn't make sense.
Well, it read like a motion to dismiss.
It read like,
I was like,
great motion to dismiss.
Are you sure that Richards or Sharici didn't write this thing? Because Lord have mercy, it's like just making the case for defense every which way, and it was frustrating.
But just so you guys know, for some reason the link isn't working for me. Is it working for you, Nate?
Yeah. I'll share. Let me share my screen.
The government of Tennessee hates you.
I know. I guess so. Could be because I'm overseas.
Yeah. That's what I was going to say. Is I don't know if it's the governor of Tennessee that hates her.
Yeah, could be.
There it is.
All right, and then I'll hide this comment now.
Yeah.
Okay. So where does it say probable cause?
Here it is. It's that defendant must establish the prosecution was without probable cause.
That needs work.
Yeah, because
it's not or. So it's not like that's one of many opportunities for the jury to find.
But if any criminal defendant can show that their prosecution was without probable cause, you start ringing the bell because you got it all, right? You got prosecutorial misconduct, you got it all, right?
Malicious prosecution.
No cause, but yeah, you're ringing the bell. Thank God. Yeah. So this is really, this is adding on to something that's already there.
Yeah,
you got the ethical violation. You got so. As soon as they put probable
how about
cause,
we just have take the prosecution outside and beat them up act? That'd be good.
And the reason why that's there is because prosecution, like I was saying, probable cause is just it's a BS standard.
It's a low standard. It's
like
low.
Natalie was saying, you can just have hey, I heard it from a guy. Oh, that's enough. There it is.
Yeah.
In Kenosha, they don't even bring the officers in usually. Well, I mean, it's different with this case, but in most other cases, they won't even bring the actual officers involved into the preliminary hearing. They have like a court officer. So basically, if there is an officer who can read and can read you the criminal complaint, that is enough for probable cause.
I read in a report from a cop who wrote it down, who heard from a confidential
there literally are
who heard it from a guy. How many levels of hearsay am I deep in this already? It's like more. As I've heard of that double level hearsay, but now we're like talking about like triple or quadruple level hearsay.
Credibility is not an issue at
apparently not.
No, and hearsay, they changed that hearsay about 10 years ago or so. They changed hearsay to being allowable in preliminary hearings because, victims didn't want to come into court. And you get something that's a widespread rule.
I have no particular objection to this. It's just fun to make fun of.
Oh, yeah. No, it's just insane. There is like the preliminary court officer. That's just like all he does is read complaints.
I've always... it's also like a personal philosophy. It's like I've always thought the rules, even where they're like literally the same, can be a little bit more strict or not, depending on the phase of proceedings. Because I've read things where there's like a motion to strike in some sort of preliminary stage of a thing. I'm like, really, guys, are we doing this now? We've got other things to waste our time on, but let's fight over this little inconsequential detail over I don't even care. It's like, yeah.
So Lord Chippy Dip says, Miss Wisco, we love you. In all caps.
Thanks.
And Ashton Upton says, great to see / hear from Natalie Wisco again. Also, Nathan, aka Photo Chat, is in the chat with questions for Natalie.
Nice.
Nate, you've got to try tagging me in the question.
We can bring him on stream, and then Natalie can ask the question she always wanted to ask but wasn't given the chance.
That's right. Yeah, the cross-examination.
But if you tag me in it, it'll highlight it for me, so it'll be more visible to me.
Were you as confused during the trial by the prosecution? Because why are they asking this question? Why is this witness being offered? What is this that you're doing? Just like half the time, I'm in my head. I'm like, I can do a better job, and I have no. It's like it's like, why are you doing any of this?
I really wish Corey would do some media about this because he has some of the best insights and other things about that.
Oh, good.
The whole time,
I want him to come onto my show.
Yeah, maybe he could just be like, if I tried this, to us.
Yeah, I was like, if I tried this case, I would. He was like, I would, He was like, I would drop it down to one issue. He's like going on all these things. I'd bring on and I mean, Corey should do more. Because he's just has a very interesting perspective with it. And like when we were doing all of the mock stuff, he was always playing prosecutor. And so, I mean, he I don't know how many hours he spent, mock crossing Kyle, but
that's probably why, like during cross-examination, when Kyle was like, because there was a fire.
Yeah, it's like, and then also the other,
why are you running? Why is it so
Yeah.
urgent?
This is like,
Yeah.
why are you asking me this? Like Corey asked me way better questions.
Oh yeah, and we like the other partner at the firm I'm at, Brian Dimmer. He, also did some practice crosses with it and stuff, and like we were trying to come up with basically anything, everything that could be covered. We want to make
Yeah.
sure is covered 10 times, and Dimmer and Corey, were able to actually stump him sometimes with some things, but I mean, no, I don't know why half they did.
The prosecution's
Kyle
case
was not. The cross of Kyle was not their worst moment. Some of their own witnesses they brought in.
No,
there's like
let's just be honest. Their whole case was proving Kyle was innocent, right? All the witnesses were proving Kyle was justified.
Yeah.
Graves Grosskreutz. Yeah, I pointed a gun at him. No, it's just like, what are you guys doing? Why again?
Yeah.
Why are we here? But that's why Kyle's lawyers started to come up now because why the hell are we even here again?
And the jurors, for the most part, had those same questions for a lot of stuff. We did debrief a couple of them, and who were the ones who were willing to talk with us. And I mean, a lot of the stuff also, not pushing on in there is because there were key people on the jury, and I know there were extra people, but like enough of them would be responding so negatively to the prosecution that it's like, we're not going to bring attention to this by giving it any sort of credence. It's one of those things you have to be there and have to see them with so much of it as things progress throughout, because they weren't having any of it, and the state was honestly kind of digging itself a hole. And
they straight up lied.
That was.
I hate to even say this about other attorneys because I understand, in a moment. But Binger got up there, and let's just call it what it is. He straight out lied. Like, he straight up said the evidence is going to show. And I'm like, no, it's not going to. And then he puts a video on that showed the exact opposite.
Mm-hmm.
So it's just like, really, what are we doing here at this point in time?
Yeah.
Maybe if we look at this picture. This pixel is the one-armed man.
The one pixel. This one little tiny gray square.
And you can clearly see he's shouldering the rifle. I'm like, you can?
No, you can't see anything clearly in that.
No way.
Thank God for you guys, though, because just imagine if he didn't have you guys, if he didn't have the $2 million, and if he didn't have all these eyes on it, right? Just imagine what would have happened. It's just
I mean, let me get clear though. He didn't have the $2 million. The court had $2 million.
Oh, yeah.
So that was fair. The court had $2 million.
The question is, who has the $2 million now, or is that still being fought over at this point? I'm sure.
I'm not going to comment on that.
That's fair. That's fair.
Does Kyle have the $2 million?
She said she's not going to comment.
He's not going to comment. Right? Now he's asking more questions.
Asked and answered.
There is a hearing scheduled for the 28th, and if it is not dealt with before then, it will be dealt with on that date.
I was happy that some of the counsel that was being suggested was ultimately not the counsel Kyle went with, because I have disdain for some of the people that were suggested earlier in the process. So yeah.
Oh, for on civil side or
no for Kyle's side.
Some of
the lawyers that were suggested for Kyle's lawyers. I was like, no, let's not go with
Rudy
Pierce
Giuliani
or
was trying to get himself
Wood
involved at one point.
How about not so much with that? That's
No, Mark.
That
was like the only time that Mark threatened to quit. He's like, if Rudy Giuliani gets involved with this, I'm.
Well, listen, you good people. I got kids to feed.
Right.
So see you guys later. Thank you guys so much for having me.
Hey Nate. Before you go, one last super chat. Alpha Foxtrot says, both my favorite Nats on one stream. Can't wait to load the playback when I get to work. So because it's referencing you, I wanted to read it for you.
Awesome. Thank you. And I'll still be watching. I'm just going to be dealing with kids now. So
sounds good.
You guys have a wonderful stream, and I'll definitely see you guys next time. Don't forget though, March 7th, U.S. women's soccer.
Okay, if you're live streaming that, I want to be a part of it.
No,
because they're going to be live streaming. We get to see their arguments. So
Yeah, and Law and Crime Network will come after you for copyright.
I know. I'd love it. I
infringement.
love it. Why can't they sue me? Why can't anybody send me any stuff like this? I can be screaming.
I'll
yell.
send you
This is
I'll send
crazy.
you a cease and desist, Nate. I love you.
Thank you. Because you're my friend. Because you're my friend.
Uh,
Later, guys.
See you, Nate. Casey also says, thank you for your participation in LawTube. I've learned so much since last fall and inspired to train to be a local CASA for abused children. I'm not sure what that stands for, but I'm assuming it's some kind of advisor or something like that. Do you guys, are you familiar?
I don't know, child abuse something advocate.
Like survivor advocate or something, maybe, I wonder.
Yeah.
God bless. But thank you. And that's awesome, Casey. I love that you decided to do that kind of work in response. And also we do have a question from Nate DeBruin. He wanted to know what your favorite moment from trial was other than the verdict. And Natalie, the questions for you.
Oh man, Nate, when you showed up with those exhibits, that was really fun because like Terry had called me earlier in the day because I had checked in with him and I was just like, Nate's got to be here at this time. And he was like, Nate's going to bring his pictures. And I was expecting like, maybe some like a by, small ones, something like that. And you walked in with these huge things and we're just like, this shit is getting real here. Yeah.
Who walks in with their own demonstratives?
Nobody does
ever.
that.
No one ever said a word of that.
No.
It's awesome. That was so helpful.
Yeah. Yeah. And it was just I think it worked very well with you because I was in the office when you were meeting with Mark talking about everything, and Nate was real feisty because at first I think he thought we were the prosecution when he got the subpoena from us because he had just dealt with these people. But no, so that was great. There were lots of great moments. I'm still going to say that, just being there for Corey's cross of gauge is one of my favorite parts. So
Yeah.
That was a pretty good one.
Yeah, that was great.
I missed being on the stream during the moment of truth though. So but I do enjoy
was
watching
there
the
for
replay
it.
of it.
yeah,
I'm so happy that I made it.
And then I did love him going on the, like, what was it, the Today Show the day after? It's like, he's like trying to walk it all
Derp,
back.
derp, derp.
yeah, he's got like such weird, like, people have asked me all the time. They're like, who do you want to play you in the movie of this? And I was like, I don't know any of that, but I really think that like young Jared Leto should be a Gage. There's just something weird about like this, like inherently like sweaty looking sunken eyes thing. That's
and then listening at least to the podcast of Binger after the fact where he apparently believes it in his own head. It's I don't know. It's something about the whole thing. It's just weird to me that Binger apparently believes that Kyle is genuinely a bad guy on some like sort of like fundamental moral level, which has I don't know, something about it's weird. Maybe I'm just too far
convince
gone.
yourself of anything.
This is
true. This is a fair
this
point.
Is true.
Yeah,
if you put yourself into enough of a vacuum, enough of a silo where you don't have voices that you can trust that are going to kind of pull the back of your shirt, right, and keep you from jumping over the edge. You can definitely convince yourself of pretty much anything.
Have you had occasion to watch any of the other trials we've been covering, Chandler Halderson or any of those
pieces?
I've watched some. After like until the holidays, I just like completely shut off paying attention to pretty much anything.
Makes sense. Totally understandable.
It just took a really long time to recover from.
I'm sure.
And since then, I really love Legalbytes being on podcast form now because I commute. So
yay.
That's like something that's helpful, is because I feel bad that I like can't keep up with everything sometimes because I really do want to, but it's like the ability to listen to something in the car, like
makes it
for me personally makes it a lot easier. And like I said, yesterday I was in Milwaukee County Circuit Court, that is like an hour drive from our office. So, when you practice in different counties, there is some drive time that we have to deal with. And, just having that available in that format is so much nicer. Cause I feel like sometimes, there are like with the trials, I want to be watching them because there are things that are very interesting to watch, just from an attorney credibility wanting to standpoint is I want to watch the witness testify so I can make up my own mind about, their credibility, their presentation, things like that.
Oh, yeah.
And I can't like necessarily do that while I'm washing dishes, but I can listen to the podcast while I'm washing dishes.
Yes.
So
Yes.
been,
And I appreciate that you've been listening. That's awesome. When you can, obviously, because you've a busy schedule. You're a working lawyer in a busy law firm.
Well, and I mean, I try to have like a boyfriend and crap like that. He takes up time, and I can't. He doesn't want to just sit around watching like other people comment on law stuff all the time.
Yeah.
So.
Yeah. Well, I think Mr. Bites has kind of been pulled into LawTube content just because of me, in the same way that I got pulled into watching video gaming content because of him. So it's we sort of have like fed into each other's like nerdisms as a result of YouTube. But sometimes that happens. But sometimes, I mean, there's obviously there's a certain point beyond which somebody's like, okay, I've had enough. I have other interests too.
Well, it's more like we also have so many other shows to watch. It's like that's the thing. Is I can watch the.
Have you guys seen the most recent season of Cobra Kai?
No, I have not.
Oh, so, have you seen any of Cobra Kai?
I haven't, but Mark loves it and talks about it around the office all the time.
I want to talk with Mark about Cobra Kai.
You could. He loves it.
I love it. That's such a great show. This season was really great.
What you should watch if you haven't is Wheel of Time series on Amazon Prime. Wheel of Time is oh my gosh, don't get me started. So if you like to read
a book series.
A book series, but it also is on auto books. Wheel of Time by Robert Jordan's. It's like the quintessential high fantasy series. It's like a 14 book series that are like thousands of pages long. And it's like a work to get through it. But Amazon made season 1 of it. And whole season 1's out. It's really good. If you like
how does it compare to the book?
It's complete. It's a lot of different in a lot of ways, but I think that it makes sense just because of the format is so much of, the appeal of the books are the world building and all of the additional information, things like that. I mean, when you're in a show, it's hard to sometimes translate that because you don't have like a narrator necessarily. So I think that they're a little bit distinct. There is differences from the storyline that have been happening in the book, but I don't think that they detract from the overall, where we're at, just because it's like book 1 out of 14 and I know where it's going to end and we can still get to the important endpoints as we go. So, I really enjoy it, but it's, the production value. Like if you really appreciate like good production value and things, it is phenomenal.
Yeah. Awesome. So that's great. I'm gonna have to check that out because that's I haven't really gotten into a good fantasy story in a little bit, so I'm gonna definitely check that one out.
If I don't, Audible loophole is you can receive a book on Audible from someone for free if you've never received a book from them before. So I can actually send you the audiobook for free of the first one.
I mean, I do have Audible. So, and you can also exchange books. If you've read one, if you've had Audible for a while, like, and you decide I don't want this in my library anymore, you get a credit back when you exchange it. So, so you can always do that if you run out of credits. Or I could also just have you send it to me if you want.
Yeah.
I'm totally down to read that. Let's talk more afterwards. So another question that Nate DeBruin had for you, Natalie, was whether the Kyle Rittenhouse case is your biggest case so far.
Oh, absolutely. This might be the biggest case that I ever do, just as terms of publicity, things like that.
That makes sense.
I don't know. Like people who didn't know me, it was weird seeing my young cousins at Christmas time because they were just like, "You've been on TV for a month straight." That's just absurd. Like I had like family member. I mean, granted, my just because I don't have a super common last name, but family members who had like people who didn't even know that I was related to them being like, "Is that your niece?" type of thing. And so it's been very strange. And I don't anticipate that really ever happening again. But
Makes sense. Unless you start your own YouTube channel, and then maybe it can happen all over again.
well, but then I wouldn't be necessarily on the case, like in there working. I'd be commenting.
That's
on
true.
it, so,
That's true. That's true.
Well, that's what most of us are trying to do at this point. We're trying to take ourselves out of practice in
Well,
the commentariat.
yeah, I love practicing. I don't know. I also just like chatting with people. And you guys are fun
Yeah.
to chat with. It's
Yeah.
less fun.
They're fun to
I
chat with.
agree. Yeah.
And
I
I
mean,
think
I
that-
love having you here anytime.
It's more of just I want to be better at what I do, and I think that you need to have talk about it with other people sometimes in order to,
Respect.
because it's the more I didn't think of that type of standpoint, and it the more people you interact with, the more thought process methods you get familiar with. It's like, oh, what would Crip think about this? Maybe I'll start doing that.
No, if this question has already been answered, I apologize. And if you don't want to answer the question, I understand. But there's still one moment in the trial that kind of confuses me, when it was like the great aunt or whatever, if I think it was Grauskowitz, Huber, who was going to testify. And the only possible reason that she can be there is as a character witness, right? She's not a fact witness. It's not like she saw anything. So her only possible reason to be there is my baby didn't do nothing wrong. But so the defense's objection to her testifying confused me, because it seemed like the benefits of being able to, well, you say your baby didn't do nothing wrong. Here are some specific things I'd like to now bring in, now that I can bring in all this wonderful character testimony. So that was one moment that confused me in the trial. So I don't know if you have commented or can comment, but it was a confusing objection to me.
Well, there were a lot of issues with that. I might have to break it down. I don't know actually if I can necessarily. Hers.
I'm putting you on the spot, and if you want to bail, that's fine too.
Well, no, I'm more of thinking like I'd have to look back at that, because in my head I'm kind of getting Huber's aunt and Carrie Ann Swart, Rosenbaum's girlfriend, confused. I mean, I don't. Yeah, I'd have to look back at that. Honestly, some parts of it just like bleed together, and that is not. And because those witnesses were like boring, in my opinion, I haven't really rewatched that part.
I would wonder.
There are other parts like Gage's stuff, like the interesting stuff I've rewatched. But
Yeah,
I didn't rewatch that stuff because it wasn't very interesting.
I would wonder if maybe part of that was that there was no guarantee that the judge would rule that, okay, yes, now you can get other witnesses in there, or other evidence in there that rebuts this character evidence. I mean, it's like technically that's what should happen, but I wonder if it's like that's still somewhat of a gamble if the court decides to rule against you on entry.
That was the idea, then fair enough.
Yeah, that's a Corey question too, unfortunately, is because those were his witnesses. So,
well, Corey, come on the stream so I can ask you things.
Yeah.
And then you can tell me how I don't know anything.
He's going to be at the NACTL conference in Aspen next week.
There you
just
go.
corner him. Just corner
Okay, there you go. I'm sure that'll go over
corner him.
Get yourself
I'm sure
to
everyone else
Aspen.
will be trying to corner him too, so I'll try to fight my way in there.
He does he is aware of the Agent 47 stuff though, and I mean, even though he is not familiar obviously with like playing Hitman, he does think it's cool. So
that's awesome.
He should think
that's
it's cool.
So great. That's so great. Also, 47 Ronin Gaming wants to know if Natalie, did you get a raise for your outstanding BTFO using millibytes? You don't have to answer that if you're not comfortable with talking about your compensation, but
my compensation depends upon my performance in general. So that's all I'm going to say about my compensation.
There you go.
I never do poorly when I perform well. So
there you go. Anani 14107 says, don't forget to donate to Nate. He's still facing legal fees for the upcoming Zeminski trial. Oh yeah, I will have to. Hey, and Nate, if you're still watching, put a link in the chat for the for your Give Send Go, and I will. I'll put it in the description below the video as well. So that people can donate if they haven't already, and if they want to, and even if they have already and they want to donate again. So Heaver Dam says, I enjoyed your guys' commentary on the Kyle trial. My mom used to clerk for Schrader in the 80s and had fun doing it. Also, Huber and Groskowitz were shot 2 blocks away from where I grew up. Holy cow. That's incredible. I wonder if your mom has any interesting stories from clerking with him all the way back in the 80s. Nerneth
Oh,
says
they're
that.
talking about Wheel of Time. They butchered the books. I know, but I'm trying to take it as something separate than what it is. You know, I if I'm gonna be like, I'm trying to enjoy it because this is like not them trying to do it in a movie format. It's definitely not a movie format thing. I mean, nothing's ever going to be made exactly the way I want it to. So I'm trying to enjoy the parts of it that are well done.
Good.
Because
Yeah,
otherwise I'm just
that's
going to have 14 seasons of being pissed off. And I get pissed off and about enough other stuff.
That's fair. That's fair. There's plenty in this life to be pissed off about, right? That are totally legitimate. And I would think, especially as a criminal defense attorney, you have no shortage of
I'm
outrage.
pissed off all the time. It's like sometimes.
Doug Murray says, hello, Alita. Loved seeing you on Nick's show last night. Kurt from one Texan to another. Congrats on the 50K subs. Yay, Kurt. Congrats.
Thank you.
Woohoo. Hi, Natalie. Good to see you back on Legalbytes. Hope y'all have a great day. Thank you so much, Doug Murray.
It was very validating to hit that milestone. So,
oh my God. Yeah. Yeah. And especially when you do it like live on a live stream, you know, like it's so nice to see that number show up and then like everybody celebrates together. It's great.
And then when Law Nerd clips my stream from last night, that might help with some further.
That's gonna be great. So Natalie, last night, Kurt and I were on. For me, it was early this morning. I totally botched the time, so I showed up like an hour late to this. But we were going over the oral arguments in one of the recent Supreme Court cases, and it was going through the audio and reading the transcript at the same time, and kind of reacting to it. And the case was about the city of Boston and their flagpoles that they have in front of the city hall. The flagpole that they use for the city of Boston, they will they have a program where people can apply to raise other flags, and the city has a whole approval process and everything. And so there was a one organization that is a Christian organization that wanted them to fly the Christian flag, and on the basis of it being a religious flag, they denied it. So there was this whole question about whether it was government speech or whether this is an Establishment Clause issue. And there was one particular point at which Kurt's brain broke. It was great. It was hilarious. He also had it was a few whiskeys in, so that didn't help.
Yeah.
But it's gonna be great when we see those clips show up on the Law Nerd Clips website.
when the clip comes up, just somebody tag me on it. Say, now that I am in the public Twitter world.
There were so many moments that broke my brain, but one of them was when the city of Boston said the reason we rejected it is because they called it the Christian flag. We asked them to call it something different, and they wouldn't call it something different. So we rejected it, not based on what it is. We literally rejected it because they called it the Christian flag. And I'm like, so all their arguments didn't make any sense anymore, because the first half of the arguments we're talking about people's perception. You know, people will see the flag flying on the flagpole. And what's the ordinary reasonable person supposed to conclude when they see the Christian flag flying outside the town hall of Boston, right? This ordinary reasonable observer. But it would have made a difference on the application if you had called it something different. I'm like, that's one of the many moments where my brain just completely shut down.
Yeah, I'm having a hard time reconciling that as well.
It doesn't make any sense. Don't think about it too hard. You're too smart. Save yourself.
My brain,
it's already too late for me.
Can't handle the cognitive dissonance.
Yeah.
It just doesn't match up.
It's too late for me. Stop thinking about it. You'll be better off.
So start with your feet. Earlier super chatted about being a CASA. That's court appointed special advocate, another name for judicial hooer. Why is the child predators or child predators always want to situate themselves close to children? So that's
a little bit mean. Their name for
their words, not mine. But that's awesome that you decided to act in the role of a special advocate for kids like that. I love that. I think that's great. AZ Beauty 7 says, thank you, Legalbytes, for having Miss Wisco on. The Rittenhouse trial was one of the best scenes since the Aaron Hernandez trial. Great job to your team, Miss Wisco, Mark Richards, and Corey. So yeah, you guys did a fantastic job, obviously. So there are some more super chats, but we can talk about another subject that's been in the news. Let's see. What else, Natalie? What else have you heard about that we can? that we can
Well,
chit chat
the
about.
one thing that I think the Drake thing is just hilarious. But,
Yes.
I already had
That's
comments
just-
about that.
But that's what I was going to say is I'm sure it's already been discussed.
But we can still talk about it because we don't know your thoughts on it. It's
think
like a lot of these subjects are kind of like playing
I
Cards Against
know.
Humanity. It's like, you know, you have the same cards that can show up, but they can play differently depending on who's playing.
Well, I mean, so many questions come to mind. I'm like, what brand was the hot sauce? Do we know that? Has that been established?
No.
Man, because that would make a big difference if you're dealing with like Cholula or Tabasco. These are the questions that I have.
Sriracha.
I'm like, what type of hot sauce are we dealing with? You know, why did we not notice that there was red in there when we
or some hot sauces are green.
Yeah.
You know, but either way,
I would never want to.
coloring
I would
should
never
tip you off.
I would think. You know, I would want to know.
I think there's a foreseeability issue here because anytime we're talking about negligence, the harm that is caused by whatever the defendant did or is alleged to have done, there has to be a foreseeability that that this kind of thing would cause the kind of harm that happened, right? So it seems like the fact that this is potentially a very, very bright colored liquid that's used in the you know, in the piece of protection which was thrown away after the encounter. The fact that
it was I mean, because even if it was colored, like you don't if a colored condom is not opaque, like you can still see inside of them.
Yeah.
So
you assume that they looked, which they were too.
I guess so.
The whole lawsuit is like, let me make sure I got this 100% straight. You're claiming that you were injured. Okay, what were you doing when you were injured again? Yeah. So my sympathy level is going to zero. I less than zero. Negative all the amounts. Yeah. And I want to figure out ways to, you know, sue her for her attempted whatever.
Well, and all this is doing is make me like Drake more. Like I didn't really like Drake before, but now I'm like, that's hilarious.
Yeah. I wasn't particularly fond of Drake before this whole thing, which I mean, then that makes me wonder. That makes me wonder, like, I mean, is this a planted story by him to drum up sympathy or something along those lines? But
very specific if he dreamed it up, so good for him.
Mm-hmm.
I mean, he's in the creative arts, right?
Fair point.
He's probably got a creative mind. But this whole question, and so just for everyone watching that isn't familiar, I probably should have given some of the background on it. There was a rumor that came from an Instagram rumor account that tends to have a lot of these sort of celebrity stories. So we don't know if it's true. We don't know if the allegations are true, but it's apparently a rumor that Drake, the rap artist, had an encounter with an Instagram model. And he used protection. Afterwards, he went to the bathroom, threw it all away. And then apparently she went in and tried to use it so that she could later on down the line get paternity from him, whatever finances support. And but because he had put hot sauce in there afterwards, she, I suppose, was injured from that. And so she allegedly is threatening to sue him, according to the story.
So she tried to artificially inseminate herself with something that was spiked with hot sauce.
Yes.
With the thrown away remnants, force paternity on somebody in order for money grabbing. So I'm not saying she is a gold digger, except I am saying that.
Yes. Yes, exactly.
White gold.
Yeah.
And
that's goes back to you can sue anyone for anything, but are you going to win?
Yeah. Which, I mean,
I want to counter sue to make her wear a sign, you know, with a hoa, you know, on there. Just make her walk up and down that because, you know, or some equivalent sign, because what she did is found fundamentally evil. It is evil.
It is.
And,
it
deserves
awful.
to be punished.
Yeah.
It's like, can we bring back the pillory? And, you know, there'll be good times.
Yeah, I definitely agree. I mean, I think assuming that this is true, I think that's a terrible thing to do to someone because
bad.
He's taking all kinds of different precautions to ensure that this does not result in, you know, bringing a child into this life that is, you know, before any kind of stages that are in any way controversial, right? Like this is not even, we're not even talking about like abortion or you know, anything, like not even the after, like the morning after pill, right? Like we're not even talking about that kind of stuff, which could be potentially controversial. This should be non-controversial at all, because he's doing the things that people say you should do in order to be you know, to protect yourself.
He's doing
in all
the
kinds
things
of
that he
ways.
can do within the scope of his ability.
Exactly.
Men unfortunately are somewhat limited in our options. So yeah, he's doing all the things that are possible. He wishes to engage in this behavior, but he wishes to mitigate his risk. This is the most he can do.
Yeah.
And apparently that's not enough, because she decides, you know, I want to go fish in this trash bin for my next baby. So fun, disgusting, evil.
Yeah. And
it
also
just burns a hatred inside that is probably not healthy.
Yeah. It's all around just weird. Nabor 605 says, if you don't mind answering, how did the jury react to Krause's closing line of "everyone takes a beating"? Thanks for coming on the show again. Do you remember if anybody reacted to that, Natalie?
I don't think anyone did, because I think they were just like,
everyone takes a beating sometimes.
That's when you're talking about kicking him in the testicles, things like that. I mean, I think there were some eye rolls, but just
that's funny.
That were in that moment, that reminded me of like the movie Snatch, where Boris the Blade is selling the gun to the guy, and he's like, if it doesn't work, you're gonna hit him with it. And I'm like, are you seriously saying that, like, oh, what you're supposed to do is I'm supposed to take my AR, use it like a club, and hit you instead? Like, no.
That's
I mean, you know, if
so
it's available as a bludgeoning instrument, I guess, you know.
Yeah.
I wouldn't necessarily do it like a club, but if you're holding it, you know, and properly indexing, you can swing the butt of the gun around if you have the flexibility for it. So, you know, there's options.
Yeah, but to say that's a requirement.
That was
ridiculous.
I had to do that first. I could have kicked him in the
okay. Shadow Fenrir 24 says, thank you, Legalbytes, for having the beautiful Miss Wisco on again. You're very welcome. Kiever Dam says, not sure about stories, but she did tell me that a guy once had to be, he's talking about his mom that was a clerk for Judge Schrader. A guy once had to be taken out of the courtroom by his arms and legs. She told me this when Schrader yelled at Binger. Oh my, that's awesome. That's hilarious. Aaron Catron, thank you for your super chat. So this whole Drake story is just, it's kind of hilarious. But who knows? I mean, I wonder if there's going to be any more information that's going to come out about it, but who knows? If not, then this is just kind of a funny point to talk about a couple times this week. Peter Watkins says, the lovely Wisco, if you were, say, Chandler Halderson, do you take a nibble or no? Oh, that's bad. That's
a bad question. Kurt, how would you answer that question?
Well, you're already going to jail forever, so you know what difference does it make at this point? I guess.
I don't know. See,
I mean, I get that the store is
how hungry I was.
They're not that empty.
Was I?
I decided to use Chandler Halderson as like, here are ways to improve on your next murder attempts, and the chat was not necessarily thrilled with me giving tips.
Oh man!
You know what I thought was not
just a nibble though. It's all good in moderation. But
yeah, not disposing the body at the woods of your girlfriend's farm. You know, maybe not disposing the body at a place that you are associated with when there are many other woods. How about literally anywhere else? How about not at the swimming hole that you go to all the time, to the point that there are pictures of you with that exact tree? How about like anywhere else?
Well,
how about common sense stuff? I say this to the possibly cannibalistic murderer, but yeah.
So, and I also read that the prosecution showed that he had his cell phone on him the whole time, so they were able to ping him at every single location.
That was also not a great. That was not a great gamer move. Leave the cell phone at home.
Those have timestamps, you know. You know, like you can with reasonable certainty tell when that cell phone was in that location. So
yeah,
that's interesting.
Leave the cell phone at home. These are mistakes.
Yeah. And Sunshine says, always carry hot sauce.
I mean, honestly, I might
There's
have
probably
some hot
better
sauce packets
spermicides
in
out
my-
there, though.
I was just thinking, it was neat hot sauce. That was something when I was in law school, that in the like I would take hot sauce packets. Yeah, I take it with you everywhere because I don't know where I'm going to need to eat this sandwich between classes, and I'm going to want my hot sauce on it.
Heck yeah. Agreed. Well, another spicy case that happened this week, or that I guess is happening. I don't know if there was any kind of real development on Friday, but the Cardi B trial has been going on this past week. She filed a lawsuit against a YouTube blogger for defamation. Natalie, have you heard anything about this case, or do you need the background?
No, tell me about it.
So there's a YouTuber that had made something like 26 videos about Cardi B, and it's where she was alleging that she prostituted herself out, did drugs, had STDs, had herpes specifically, and so she presented these all as fact, and so Cardi B decided to hit her with a defamation lawsuit. And for some reason, this has not settled. I mean, it's the information that has come out at trial is wild, because for anyone that doesn't know, for defamation, you have to show first that the defendant made an untrue statement, second, about the person that's suing, third, that they made the statement with at least negligently. But when we're talking about a famous person like Cardi B, it's recklessly. At least recklessly. It's actual malice is technically the term for it. And then you have to show that there was some kind of damages for it. Now, because of the fact that we're talking about things like STDs, prostitution, and drugs, this is also potentially a defamation per se case, because it's basically where you don't even need to show that there was crazy reputational harm because of the nature of the lies themselves. So in this case, like the standard is so high for actual malice for celebrities, like for any celebrity to win a defamation case, it's really hard, because they're already out there, they're already part of the public conversation. And the idea behind that is that, people should be able to comment on these public figures that have a lot of influence across the country. When it comes to politicians, like, we've got to be able to talk about these people, because otherwise like I said, like there's a competing level of power between them and the average person. But in this case, what came out at trial was, according to live tweets that I was following from people in the courtroom, Tasha K admitted on the stand this week that and I don't know why she so brazenly admitted this, but she said that she knew that what she was saying about this stuff was probably not true, but she said it anyway, which is textbook actual malice.
Yeah. That's
So, and I'm also not like, I'm not someone who usually listens to Cardi B. I'm not a huge Cardi B fan. Her style is very different from my style, but I've got to say, in this case, like, she's gonna win. She's gonna win, and she's gonna wipe the floor with Tasha K here, because there's potentially punitive damages involved. So.
Hard not to win when they say, yes, I had the actual malice. Yes, I knew what I was saying was false, and I was doing it deliberately for financial advantage.
That's like,
there's that down. Thanks.
That's like the he only shot me after I pointed his gun at my head.
Yeah.
My gun at his head. It's like, okay, that's a clean wrap.
Exactly. So that's fun times. So in this kind of a case, somebody mentioned in the chat that she should use the Rachel Maddow defense, also known as the Tucker Carlson defense, where basically they were hit with defamation claims related to the elections, or at least Tucker Carlson was related to the elections. I can't remember what the Rachel Maddow one was, but it was around the same time. But in response to the lawsuit, their defense, they had a similar defense, even though they were two different cases, where they basically said, we are, like, I am entertainment, I am not news, and no reasonable viewer would think that what I am presenting on my program is being presented as fact.
Mhm.
They all the reasonable person understands that this is just for hyperbole, just for entertainment purposes, which is kind of crazy that they won on that, because if you actually watch their programs, they seem to present themselves quite factually.
Yes, absolutely.
In both cases. So
It's not like it's South Park. I mean, it's
right. Or some stand-up comedian who goes up and,
Mhm.
and has, like Tim Dillon on his show. He says things in a way that's like, if you were just to read the words on a page, it sounds like he's making statements of fact, but you can tell that he is being very clearly sarcastic in everything that he says. Yeah. Anyhow. Yeah.
Mhm.
So let's get some more. There's at least one more super chat. Dapper Dave 2021 says, going to ask a controversial question. Why do you suppose Binger didn't bring Jump Kick Man as a witness to make it a race thing despite criminal record?
Well, I mean, there's a lot of issues with that. Because there has to deal with at what point in time Jump Kick Man was identified with being Jump Kick Man. Why wasn't he brought in? Things like that. I mean, our understanding with Jump Kick Man, from what we understood, was he didn't come forward as a person until like halfway through the trial. He wasn't listed as a witness. He wasn't done all this, and they actually weren't even able to verify his identity, being in himself. He never actually met with the prosecutor's office. It was the issue of they were going to meet with him to verify it was him, then discuss things with him, and they never actually even met with him because he was like, I'm only going to meet with you if I get complete immunity from all this stuff. So, I mean, it deals with issues of, when did this actually happen? And I think that there's probably more involved that I, am obviously not aware of. I don't think that Jump Kick Man, didn't do himself any favors, because also not identifying himself until later. I wouldn't want to bring him as a witness, because if I was the person crossing him, I'd be like, you only brought yourself forward now, right? When this is in the middle of national attention, right? When all these people are paying it. I mean, it's the person, Jump Kick Man himself, was wearing a mask during the whole thing. And it is hard, unless he were to come back as the, having the exact same clothing, something like that. Was this even Jump Kick Man? And I think that there's just tons of issues related to that, I mean, I still don't even know if it was Jump Kick Man who actually identified himself, because, I mean, we never got to meet with this person. So, I mean, what if it wasn't him and it was just somebody trying to get attention? I mean,
that's fair too.
Mhm.
That's also fair. Yeah. So there were a number of issues.
There were a lot of issues with that. Yeah. And also, I mean, at that point, they've admitted he was unidentified and they didn't know where he was, things like that. I mean, it also,
that
like
doesn't,
it
doesn't help with
to a
those
certain
questions.
extent. It doesn't help with those questions. It's like, nope, we were dumbasses and couldn't identify who he was until he told us who he was, halfway through a trial. That doesn't do them any favors either.
Yeah.
Because it makes them seem more incompetent.
Yeah, that's true. That's true. Yeah. Keone wants to know, is there a reason why the allegedly injured, so this is going back to the Drake situation, the hot sauce bling. Is there a reason why the allegedly injured is only referred to as an Instagram model instead of named? Drake is named, why not her? I think that the real spice of the story is that Drake is the one that was involved. And I don't know. I mean, so first off, this like I said, it's a rumor. It could all not be true, right? So there could be no person that is this supposed Instagram model. So that's one thing. Another reason could be, I mean, if this is somebody who sees themselves like this Instagram drama blogger or whatever, they might see themselves as kind of a journalist, and so they may not, if they got the information straight from the Instagram model herself. It could be that they want to protect their sources. I don't know, or general confidentiality sense. I don't know.
Well,
or it could all be fake.
And it can also be a clickbait thing. If you're saying that Drake is accused by Beth Smith, I mean, people don't necessarily know who that is, they're going to go past it. But when you even just see the words Instagram model, then that kind of makes it as part of a larger thing, as opposed to being an isolated incident, as it brings into question, you know, the truthfulness and motives of all Instagram models type of things. All it is sensationalism. And they're trying to get the headline that's going to attract the most attention. And Drake, you know, being an Instagram model is going to, you know, bring up more attention than it is just saying the person's name if people don't know who she is.
Yeah, that's fair.
Because you would also have to put her name in there. It'd be like Beth Smith, Instagram model, for any way to have a context. And at least this is, you know, cuts down things.
Yeah. Quicks DC614 says, have you heard of Will Husel 25 counts of pint or part offing? I'm not sure. I don't know. I haven't heard of this. I'm not sure what you're referencing. Do you know, Kurt? Do you know? No. Okay. Then no. Deep Surface says Allison's BBD hypnotized Binger into hating Kyle. I don't know. Maybe. Not applicable. Says, God bless you for your tremendous work, Miss Wisco. And I agree.
Thanks.
So this has been wonderful. And I think that we're probably going to cut it off now.
And I have to head out, like I messaged you anyway, so I got to get going.
Yeah. And this has been great. Thank you so much for coming back. I love having you on, and I love that now we can start talking about some of these other cases that have kind of popped up and sort of get your sense of LawTube. So yeah, and now you've met Emily, you've met Nate, you've met Uncivil
Kurt,
Law.
yeah.
So this has been great.
Yeah, so thanks for having me on. I don't tweet much, but I guess I do have a public Twitter now. I'm at NL Wisco.
Linked in the description too.
Oh, okay, cool. Yeah. I don't really tweet much. I'm kind of a voyeur on the internet a lot. And I just like to be creepy and watch other people. But when you put your information on public, that's what you're going to get. Is you're always going to get people creeping around.
That's true.
I'm
That's
just owning
true.
the fact that I'm creeping.
All right. Well, we all do it to a certain extent, right?
I know. Well, I mean, and I don't know. That's one of my. I just like knowing things. That's like my Gretchen. The Gretchen Wieners in me is like my hair is full of secrets, and I like to know everything possible that I can. So.
Well, I respect that. I'm the same. I feel like the same way, especially on law. One of the nice things for me personally about my channel is it gives me the chance to read so many cases.
Yeah.
And it's like I have over 1,000. I think I have over 1,100 videos on this point on my channel. So many different courts of appeal cases, so many different Supreme Court cases, and I just love learning new stuff. It's fascinating and fun.
Yeah.
And then I can geek out about it with you guys.
Absolutely. That's like the best part.
You got any more than Marbury versus Madison? Need some of that Marbury versus Madison.
Well, thank you again. I am gonna head out because I got a thing. But
I'll end the stream now, and I'll just say that I added Kurt into the description and into the title of the video. And Natalie's Twitter handle is also linked in the description. I'm also about to add Nathan DeBruin's Give, Send, Go. So if anybody is interested in checking any of that stuff out, go ahead and check it out. I've also got a clips channel, which I haven't been adding to recently, but I'm this next week I'm gonna be adding a bunch of stuff to it because there's a big backlog. I've been working with a really great editor who's been working on all of these clips, and I want to make sure that his work doesn't go to waste because he's been doing such a great job. So anyhow, besides that, and there's also the podcast, links also to that in the description below, and otherwise you can find us all on all the social media platforms. And with that, we will say goodbye.
Bye.